Welcome to today's program titled Navigating the Residential Mortgage Landscape During the COVID-19, What Lenders and Servicers Should Know About the CARES Act. At this time, all participants are in listen-only mode. For those of you who are logged into the web presentation, you are encouraged to submit questions throughout the conference by typing them into the text box on your screen. For those interested in obtaining CLE credit for this webinar, an attendance verification code will be read during the presentation that will be required on all CLE attendance affirmation forms. Please write this code down. It will not be reread, and it is required for CLE credit. Copies of the webinar recording and the PowerPoint presentation will be distributed to attendees in the days following the webinar. At this time, I'd like to turn the program over to Ms. Tanya Esposito. You may begin.
Great. Thank you so much, Donna. And I want to welcome everyone to our webinar today. We appreciate you logging in and participating along with us. We're going to spend some time today, obviously, talking about the residential mortgage landscape in the wake of COVID-19 and focusing specifically on what lenders and servicers should know about the CARES Act. But before we get started, I wanted to let everyone know that Seyfarth Shaw does have a pretty robust resource center focused on COVID-19 issues, and we are preparing materials pretty much daily that we hope you will find useful. If you would like to subscribe to those updates, you can log into the website here in front of you, www.seyfarth.com/COVID-19. You'll see updates not only from our Consumer Financial Services Practice Group at Seyfarth, but others that, again, you may find interesting that touch on other industries. And the final thing I'll say is that we are, as a Consumer Financial Services Practice Group, going to be rolling out a series of webinars focused on some other topics that we think you'll find of interest, including student loans and bankruptcy, collections, lender liability, and some others. And of course, we will do an update in the mortgage space if we have something that's noteworthy to update you on. So with that, just a little standard legal disclaimer. The contents of what we're going to present for you today obviously should not be construed as legal advice. This discussion and the information that we're going to provide is intended truly just as general information. If you have a specific legal question or a specific legal need, we encourage you to contact an attorney to talk about your specific situation, and certainly if it's something that we can help you with, we're happy to, so just let us know. So today I'm joined with David Bazar. He is co-chair of the Consumer Financial Services Litigation Practice Group at Seyfarth. Myself, David is in Boston. Myself, I am also co-chair of the Consumer Financial Services Practice Group. I'm based in Washington, D.C., and Annie Dunn. And Annie is a litigation associate in the Consumer Financial Services Practice Group, and she's based in Boston. A little overview of generally what we're going to talk to you about today. So we're going to start by providing you an overview of the CARES Act. I'm sure that most of you know about it, have read a lot about it, have received a lot of information in your inbox about it, but we're just going to provide a very general overview of the CARES Act as it, in general terms, and then we're going to focus specifically on the provisions that affect the mortgage industry. I'm then going to talk to you a little bit about credit protection and some CARES Act language and the legislation itself and how it affects creditors and credit protection. We're then specifically going to get into the CARES Act and the mortgage industry. We're going to talk a little bit about foreclosures and evictions during COVID-19. And then we have a handful of takeaways and considerations that we're going to raise for discussion amongst ourselves, but we'll also be opening it up, to you all for any questions that you might want to raise for us. And as was mentioned at the beginning of the program, you can go ahead and enter those questions in the bottom of your screen, and we'll do our best to get to those as we wrap up our portion of the presented program today. So starting off, as I mentioned, with a little overview of the CARES Act. So as most of you know, I'm sure, it was signed into law on March 27th, 2020, and the goal of the legislation was aimed at reducing the economic impact of the coronavirus pandemic. It authorizes $2.1 trillion in aid to various sectors in the economy, and there are really a few groups that we think will see the greatest impact from the CARES Act. And so if you sort of look at it from a very macro perspective, it's individuals, small businesses, big corporations, hospitals, public health entities, state and local governments, and education. And so this comprehensive piece of legislation that includes many things also reaches out or addresses, I should say, as I mentioned earlier, credit protection and goes specifically to residential mortgage loan and residential property provisions, and that's the scope of our discussion here today. So there are really 4 sections of the CARES Act that we're going to spend time on with you and dig down a little bit deeper, and those are Section 4021, which again addresses credit protection, Section 4022, which goes to the foreclosure moratorium and consumers' right to request a forbearance, Section 4023, which goes to multifamily property owners with federally backed loans that may seek a forbearance, and Section 4024 that goes to the temporary moratorium on eviction filings. We're going to cover each of these sections in turn as we move throughout the program today, starting with credit reporting on behalf of landlords, lenders, and servicers, the forbearance relief available to borrowers, and the foreclosure and eviction moratoriums, as I mentioned previously. So turning now to credit protection. Section 4021, as I mentioned earlier, is a modification of the Fair Credit Reporting Act. And this is a modification through the CARES Act that precludes furnishers of information from providing or reporting, rather, any kind of an accommodation that's afforded under the CARES Act. And so according to these modifications, furnishers have to continue to report the consumer using the consumer's account status, either current or delinquent, at the time the accommodation began. So what that means is that if at the time, a borrower picks up the phone and requests a forbearance under the CARES Act because they qualify for it, and we'll talk about what that means and why in a minute, if the account was up to date and current at that particular point in time, then that's the information that must be reported as part of this legislation. And there are some specific factors around that we're going to talk about as we move through the presentation in terms of keeping accurate records and the types of just logistic issues you can run into as a lender or a servicer where you're making these types of accommodations. Just things to keep in mind that will hopefully avoid any further liability or regulatory or enforcement issues for you. And so again, this is just restating what I just said, that the CARES Act requires lenders and servicers to be very careful in evaluating a borrower's credit information and status when providing that information to the credit reporting agencies to make sure that you are in regulatory compliance and to minimize that litigation risk. So the CFPB, in response to these changes that apply according to the CARES Act, issued a non-binding policy statement, and it announced a flexible, quote-unquote, supervisory and enforcement approach for compliance with the FCRA and Regulation 5. And the Bureau, in this guidance piece, stated that it doesn't intend to cite in an examination or bring any enforcement actions against furnishers that exceed deadlines to investigate consumer disputes, so long as they make good faith efforts to do so as quickly as possible. And so, as we know, the FCRA requires that furnishers respond to disputes received from credit reporting agencies within 30 days in most circumstances. And we're going to, again, talk about this more at the end of our presentation today, but even though the CFPB may decide to not bring an enforcement action against a furnisher for not being able to respond within that 30-day window, a consumer is still likely to have a private right of action under FCRA investigation is not completed timely. And so just something to consider. But, within this statement and its comments, the CFPB recognizes that a number of disputes are likely, the number that's out there is likely to rise given the reporting requirements under the CARES Act. And as a result, in this statement that they published, the CFPB reminded furnishers to take advantage of statutory provisions that eliminate the obligation to respond to disputes that it reasonably determines to be frivolous or irrelevant. So again, that's the guidance from the CFPB, but of course, furnishers should be careful to not label a dispute as frivolous when it may not be, because that could certainly lead to increased exposure and litigation. So now we're going to move into the CARES Act in the mortgage industry, and I'm going to turn it over to my partner, David Bazar. David?
Hello, everyone. So we're going to transition now to Section 4022 of the Residential Mortgage Act, which is the part that deals with the foreclosure moratorium and a borrower right to request a forbearance. What this deals with are residential borrowers who have a federally backed mortgage loan. Now, according to the Urban Institute, that is about 62% of all first mortgages in force in the United States today, if anybody's wondering how many. That's the best number we've seen put out there so far. Basically, a federally backed mortgage loan is one that, and these are enumerated specifically in the law, but basically one that is either first or subordinate lien on residential real property, including individual units of condominiums and cooperatives that were designed primarily for occupancy of 1 to 4 families and that meet one of the following 6 criteria. Those criteria and basically involve whether the loan was insured by the FHA or and was subject to a conversion, a home equity conversion with the FHA, guaranteed by the HUD Act of 1992, Sections 184 or 184A, which have to do with Native American families and certain Native Hawaiian families, guaranteed or insured by the U.S. Department of Veterans Affairs, made, guaranteed, or insured by the United States Department of Agriculture. And here's a big one, purchased or securitized by the Federal Home Loan Mortgage Corporation, which is Freddie Mac, or Federal National Mortgage Association, which is Fannie Mae. So those are your federally backed loans. And so servicers have an obligation to determine if the loan is one of these basically 62% that are out there, and if it is, and somebody calls and says, hey, I want my mortgage relief, I can't pay my mortgage because of a direct or indirect financial issue with COVID-19, there's that word shall that's in the law about giving them this relief. So the details of the forbearance relief are as follows. During this covered period, residential borrowers with federally backed mortgage loans are allowed to temporarily postpone their mortgage payments. The initial forbearance period is up to 180 days, and it can be extended by another 180 days if it's requested by the borrower. The borrower must affirm that he or she is experiencing that financial hardship I mentioned due to COVID-19, that's directly or indirectly. And here's another key. No other documentation or proof can be required. So the servicer is not allowed to ask for other information or other proof about the nature or extent of the economic harm that they're experiencing. The borrower can shorten or even halt the forbearance period at any time by contacting the servicer. During the forbearance period, a lender or servicer may not assess any fees, penalties, or interest that would have not been charged to the borrower if he or she had made their payments timely under the terms of the mortgage contract. If the lender or servicer makes an accommodation under the Act, it must, as a furnisher, continue to report the account as current. That's what Tanya was talking about a moment ago, if the borrower fulfills the terms of the accommodation under the CARES Act. So in other words, they can go through the entire forbearance period up to a year, and the Act treats them as if they were making their payments timely during this time period. If the account was delinquent before the accommodation was made, The furnisher is permitted to continue reporting the account as delinquent, however, unless the account is brought current. The reporting requirements under the CARES Act, which is Section 4021, apply to consumer accounts between January 31st, 2020 through 120 days after the end of the COVID-19 national emergency. Now, there's a separate section in the Act for multifamily properties, and that's Section 4023. As with Section 4022, it provides relief for federally backed mortgage loans, but in this instance, federally backed multifamily mortgage loans. And that is a loan that otherwise had the prior characteristics that is secured by a lien against a property comprising 5 or more dwelling units. In this instance, this includes any first or second mortgage loan secured by a lien on the property, and that it basically is insured, guaranteed, supplemented, or assisted by any officer or agency of the federal government, or under or in connection with a housing or urban development program administered by the Secretary of HUD or any such agency. It also includes, as before, such mortgages that are purchased or securitized by Freddie Mac or Fannie Mae. It does not include loans for temporary financing, such as a construction loan. Multifamily borrowers are prevented, lenders are prevented from charging fees or penalties or evicting any tenants for non-payment of rent during the forbearance period, and upon completion of the forbearance period must provide all tenants with a 30-day notice prior to requiring a tenant to vacate. The above discussed consumer credit reporting protections pursuant to Section 421 above also apply here. So if a servicer or lender makes an accommodation under the CARES Act, it must, as a furnisher under the Fair Credit Reporting Act, continue to report the account as current if the consumer fulfills the terms of the accommodation. However, as before, if the account was delinquent before the accommodation was made, then the furnisher is permitted to continue reporting the account as delinquent unless the account is brought current. Multifamily borrowers can request a forbearance either orally or in writing, triggering a duty by the servicer to document the hardship and provide an initial 30-day forbearance. Financial hardship is not defined in Section 4023. There is no specific requirement to demonstrate a hardship. The forbearance may be extended for up to 2 additional 30-day periods upon request by the borrower during the covered period and at least 15 days before the expiration of the initial 30-day forbearance. No moratorium on foreclosures of these mortgages, however, and the covered period has a definition this time in 423. It is defined on the date in which the CARES Act became law, which is March 27, 2020, until the sooner of December 31st, 2020, or the termination of the date of the COVID-19 national emergency. And that brings us to the covered period. So unlike Section 4023, Section 4022 does not define the term covered period. Prior draft of Section 4022, this is the section dealing with the 1 to 4 families, contained a definition of covered period that was identical to that contained in Section 4023, but it wasn't enacted into law. The covered period is defined on the date in which the CARES Act became law, March 27, 2020, until the sooner of December 31st, 2020, or the termination of the date of the COVID-19 national emergency. The definition was struck from Section 4022 of the final text of the CARES Act, and what that means is anybody's guess. It probably will be the subject of litigation, and potentially extensive litigation, as to what that covered period is under Section 4022. I'm not sure we have a view yet. That's something in akin to legal advice. There are possibilities. I'll just mention 1 or 2. One possibility is that as long as the borrower was not had not had their loan accelerated at the time that the act became effective, they are entitled to a request of forbearance. That's one possibility. Another possibility is that you would apply the same definition in Section 4023, utilizing the principle that, well, it appeared there, and maybe it wasn't intended to mean something different in 4022, even though it had once appeared there and didn't appear there again. So it was just superfluous, or maybe it was intentional that it was pulled out. If it was intentional, again, you'd look to something like a different definition for, well, if the loan hadn't been accelerated yet. So with that, I'm going to turn this over to Annie to talk about the foreclosure moratorium.
Thank you, David. Before I begin my portion of the webinar, I am going to provide all participants with the CLE code. The CLE code is SS as in Seyfarth Shaw 4429. Again, that is SS 4429. You will need that code. That is the only time it will be repeated during this webinar. So one more time, please write it down if you need it. SS as in Seyfarth Shaw 4429. As David was just discussing, there are two different provisions of the CARES Act which deal with residential mortgages. Those are sections 4022 for 1 to 4 family mortgages, and section 4023, which deals with multifamily mortgages. The CARES Act includes a blanket foreclosure moratorium on servicers and lenders of 1 to 4 family federally backed mortgage loans for 60 days beginning on March 18th, 2020. This moratorium includes initiating a foreclosure, moving for judgment in a foreclosure, and executing a foreclosure judgment. And that is for 1 to 4 family federally backed mortgage loans. The CARES Act notably does not include a foreclosure moratorium for federally backed multifamily mortgages. And that is for properties that cover 5+ families. In addition to this federal legislation, which governs foreclosure moratoriums, both judicial and non-judicial foreclosure states are issuing their own moratoriums. For example, the state of Iowa has issued, which is a judicial foreclosure state, has issued a governor's proclamation dated March 22nd, 2020. The governor of Iowa temporarily suspended the provisions of the Iowa Code that allow for the commencement or continued prosecution of foreclosure proceedings. This foreclosure moratorium, unlike the federal moratorium, which lasts for 60 days, remains in effect for the duration of the governor's proclamation of the coronavirus emergency. Obviously, at this point in time, no one is certain when the emergency will end, either nationally or in Iowa. So that is a time period that lenders and servicers need to be watching closely. Similarly, in New Hampshire, which is a non-judicial foreclosure state, Governor Sununu issued an emergency order pursuant to an executive order on March 4th, 2020. Governor Sununu prohibited all forms of foreclosure during his COVID-19 emergency declaration. In addition to these governor's proclamations, there are state judicial orders that prevent foreclosures from being prosecuted at this time. And there is also pending legislation. For example, in both Massachusetts and Alaska, there are currently competing bills, which are pending before each state's legislative body. We are closely monitoring those situations and will report any action that is taken on those bills in the future when it comes into effect. The effect of these various state moratoriums means that lenders and servicers not only need to not only remain current on all state-level moratoriums after the 60-day federal moratorium expires, but they also need to remain current on these moratoriums during the federal moratorium period because they affect multifamily properties and properties that do not have federally backed loans. So while the federal CARES Act covers a moratorium on foreclosures for 1 to 4 family homes with a federally backed loan, these state-level moratoriums are not delineating mortgage loans that are backed by federal government versus other entities, and for the most part are not delineating a single family or 1 to 4 family property from a multifamily property. This means that there are a number of traps that an unsuspecting lender or servicer could fall into and people need to be mindful of this patchwork across the nation as they move forward with any foreclosure. In addition to a moratorium on foreclosures, the CARES Act also has a moratorium on evictions. Section 4024 governs the eviction moratorium under the CARES Act. In order to determine how the moratorium may impact a specific property, there are 3 questions which must be considered. These questions must be considered sequentially. The first question is, does the specific property fall under the moratorium provision? If it does, what exactly does the CARES Act prohibit? And what is the enforcement mechanism of this eviction moratorium? We'll cover each of these questions in turn. Section 4024A applies the moratorium to properties that either participate in a covered housing program as defined in the Violence Against Women Act or the Rural Housing Voucher Program, or that have a federally backed mortgage loan or a federally backed multifamily loan. As we discussed before, federally backed mortgage loans and multifamily loans are defined by the Act and include loans securitized by both Fannie Mae and Freddie Mac. With respect to this eviction moratorium, it has been estimated that this will apply to roughly 12.3 million of the 43.8 million U.S. rental units, or approximately 28% of all rental units in the United States. What exactly does the moratorium prohibit? So if you determine that the moratorium applies to a property, either because it has a federally backed mortgage loan or a federally backed multifamily mortgage loan, or it participates in VAWA or the Rural Housing Voucher Program, then during the 120-day period beginning with the date of the enactment, a landlord or lessor or owner may not make or cause to be made any filing to initiate a legal action to recover possession of a dwelling from a tenant or occupant for non-payment of rent or non-payment of other fees or charges. Additionally, during this 120-day time, an owner or lessor or landlord is prohibited from charging fees, penalties, or other charges to the tenant related to such non-payment of rent. It's important to note that this is unlike the HUD moratorium, which had been issued earlier in March. That moratorium stayed certain pending evictions as well. This moratorium under Section 4024B does not stay pending evictions. And once the 120-day period expires, a lessor may not require a tenant to vacate the property sooner than 30 days after issuing or providing a notice to said tenant. Notably, a notice cannot issue until the 120-day period has expired. So effectively, tenants cannot be evicted until 150 days after the CARES Act went into effect. CARES Act went into effect on March 27th, 2020, and therefore this moratorium will end on July 25th, 2020. And notably, this moratorium under Section 4024 applies even if a landlord does not avail it, or landlord or an owner of a multifamily property does not avail itself to a forbearance under Section 4023. As David discussed earlier, Section 4023 applies to multifamily properties. And if an owner of a multifamily property avails themselves to a forbearance under 4023, they cannot evict a tenant until they issue notice at the end of their forbearance period. Much like Section 4024, that notice period is 30 days. But here, it's very important to note that even if you do not avail yourself to the forbearance protections under Section 4023, you are prohibited from initiating an eviction proceeding until the 120-day period has run and the 30-day notice has issued. The next question, how will the moratorium be enforced? This is another question that has been left open by the CARES Act. As of the date of this webinar, the enforcement mechanism is still unknown. There are some potential scenarios which may come into effect. The administrator of a covered program may take action if they believe that an owner of a property has undertaken an eviction proceeding during the 120-day covered period or during the 30-day notice period. The other possible way that we believe this may be enforced is tenants themselves may attempt to use the act as a defense in an eviction proceeding. They will likely raise it and say that the eviction was brought in violation of the moratorium. And while this has not been the topic of any litigation yet, we anticipate it is one way that the plaintiffs bar will seek to use the CARES Act to protect consumers. We're closely monitoring the enforcement of this provision and all provisions of the CARES Act, and will provide timely updates. One more thing to note with respect to private litigation, tenants or occupants may not know if a property qualifies for the moratorium. Tenants' rights activists across the nation are raising concerns that tenants won't actually receive the protections afforded to them under the CARES Act if they are unable to determine if their landlord or the owner of the property comes under the ambit of the Act. This could result in litigation seeking to enforce the moratorium on properties that do not meet the criteria. So this is another area where we will be watching. And as I discussed before, a number of states had put in place foreclosure moratoriums. Same has happened with respect to evictions. A number of states have issued broad eviction moratoriums, notably in the District of Columbia. The District of Columbia Superior Court issued an advisory on March 13th where they suspended evictions of all tenants and foreclosed homeowners. Similarly, on March 25th, 2020, the governor of Kentucky issued an executive order ceasing the enforcement of orders of eviction for residential properties for the duration of the state of emergency, which was declared in Kentucky on March 6th. In Maine, an emergency order and notice was issued by the Maine Supreme Court on March 18th, 2020, in which the Maine Supreme Court ordered that no proceedings will be scheduled or heard for evictions through March 1st, 2020. In New Hampshire, Governor Sununu issued Order Number 4 pursuant to Executive Order 2020-04 on March 4th, where he suspended all evictions during the emergency declaration. As we discussed before, there is no end date right now for the emergency declaration. So for states like New Hampshire and Kentucky, there is no end in sight right now for these state eviction moratoriums. Additionally, other states have enacted similar legislation or orders that have similar effect. Notably, Arizona has a very interesting state moratorium.
They're offering very specific relief for certain categories of renters. In Arizona, they have specifically called out protections for healthcare workers. And in addition to federal and state governments issuing moratoriums, before there was federal action and state orders went into effect, authorities in cities across the nation were issuing their own bans. Among these early trailblazers were Seattle, Washington, Denver, Colorado, San Francisco, and Los Angeles. The result of these federal, state, and local moratoriums is a checkerboard of laws and orders across the nation. As we discussed before with respect to foreclosures, this will require some very careful planning on the part of lenders and servicers on determining if and when a moratorium has expired. As I discussed before, for example, the state of Maine has put an end date on their moratorium of May 1st, 2020, but if you look at their neighboring state, New Hampshire, there is no end date in sight. So lenders and servicers with a national customer base need to be watching these state-level moratoriums, the federal-level moratorium, and whether it applies, and in some cases, local ordinances and moratoriums. And we're now going to move on to a couple of questions that we have seen as kind of hot questions in this space. A lot of people are wondering how many residential mortgages are affected. To date, official numbers have not been released by either federal government or any other official entities. However, we are hearing that it's estimated that about 62% of first lien mortgages are federally backed. As David discussed with respect to sections 4023 and 4024, there are extreme ramifications for those 62% of mortgages. Those borrowers are entitled to forbearances. In some cases, there are foreclosure moratoriums in place. So that is affecting more than half of the first lien mortgages throughout the country. And lenders and servicers have seen a surge in forbearance requests since the CARES Act was passed. This has been a hot topic in both the mainstream media, such as CNBC, and industry groups. Industry groups have been closely watching forbearance requests, and yesterday afternoon, CNBC reported that there was a near 2,000% increase in forbearance requests over the past 3 weeks. And interestingly, this large jump in forbearance requests must be considered with an eye towards the volume of calls that are currently being received by lenders and servicers. There are reports now that wait times have increased by almost 9 times what they were just 3 weeks ago. 3 weeks ago, people were reporting wait times of about 2 to 3 minutes to speak with their servicer. The average wait time is now over 18 minutes. So obviously, there are a lot of people calling in to find out about these forbearances, whether their mortgage qualifies, and taking the next step. So with that, I'm going to turn the presentation back over to David. Thanks.
So we're going to move now to the chaos. What's going to happen with all this? Who's ultimately going to foot the bill? And here's the awful lawyer's answer. Nobody knows. The CARES Act does not include any monetary relief, either for borrowers or for the mortgage industry. And that's obviously causing a lot of consternation amongst our constituency that's on this call. All the Act says is that the servicer can't make the borrower pay and has to treat them as current, And then all these contracts that the servicers have with the owner investors typically require them to make the payments anyway, even though they're not from the servicer, even though the servicer's not getting the money. So right now, the servicers of the world have been heavily lobbying to try to find a way to tap into some funds. The banks are doing a little bit better than the non-banks because the banks have the opportunity to tap into Fed funds, funds from the Federal Reserve, by virtue of their bank statuses, but the non-bank servicers don't. And so that's a real challenge. And some of the non-bank servicers have been complaining that they are possibly going to fail as institutions as a result of COVID-19. A lot of this depends on how long this actually goes on and how many folks actually claim the forbearances. The worst case predictions that are out so far say up to 50 million borrowers may seek them, but those are predictions and no one really knows. So I wish I had better news on that score, but there's just a lot of unknowns about where's the money going to come from. Now that's not only for the institutions, but eventually for the borrowers as well. This time around, when we get to the end of these forbearances, what's going to happen to the borrower's obligation to now pay? There's guidance that's come out just very recently in the form of a joint statement from all the various prudential regulators, including the OCC and CFPB and others, in which they have provided at least some guidance as to what their thinking is. They don't say that that's the guidance that's designed for what eventually happens, but it is. And that joint statement basically says that servicers need to treat these forbearance applications as incomplete loan modification applications under Regulation X, and in so doing, and that's for all purposes, provide all of the various forms of notice. Now, why am I bringing that up in this space? It's because you can get a hint as to what their thinking is, because what they're saying is that all of the usual information that you need to give to a borrower about the consequences of potentially entering into a loan forbearance agreement that they may have to pay back, and that well, as of right now, they have to pay back, and that might have additional opportunities for further hardship relief, for example, in the form of a modification or other forbearance agreement or whatever down the line, that all those notices need to be given. So their viewpoint is just like reality, nobody knows yet, but you better give all the notices that are required for the situation when a borrower puts in for an incomplete loan modification. Now, why did they choose incomplete loan modification? Well, it's hard to get into their heads, but I'm going to take an educated guess that the thought process was that's what a forbearance is in this context. We don't know yet what the ultimate result will be, so treat it like an incomplete loan modification, because that kind of lines up nicely with all the information that we would want the borrowers to have. So at the end of the day, what's going to happen? Nobody knows. Maybe there'll be another bailout or partial bailout with respect to certain or all. I mean, a lot of it depends on how many of these borrowers actually take advantage of the forbearance period and the like, and servicers eventually will be responsible for administering all this. Whatever it is that the government decides will be whatever number bailout that may come down the line, if any, for all these borrowers, because as we all know on this call, on this webinar, a forbearance agreement means you have to pay the money back when the forbearance term ends. Okay. So what about non-federally banked residential mortgage loans, which are not subject to the CARES Act? Well, here as well, lenders and servicers are still subject to interagency guidance that's been issued by the CFPB, the FDIC, and others that I was talking about a moment ago, which encourage financial institutions to work prudently with their borrowers who are unable to make their payments due to the effects of anything, including COVID-19. And so it's important to keep in mind that just because a mortgage loan may not be actually subject to the CARES Act does not mean that it is in the consumer space entirely unregulated when it comes to requests for hardship assistance. So with that, I'm going to turn it over to Tanya to talk about what happens with these non-federally banked residential mortgages as well. Tanya?
Yeah, I mean, thanks, David. What I would add to that is I think that's an excellent point. The fact that these, mortgages that are not federally backed and are therefore not subject to the CARES Act, it doesn't necessarily mean that there's no regulators that are looking at them and that are, issuing guidance. So as this interagency statement suggests, there's, an urging to sort of encourage them to work prudently with borrowers. And that, I think, leads nicely into one of the points that I made earlier and that I was going to reiterate and extrapolate a little bit in my next slide, which is thoughts about compliance and litigation exposure. I think it's really important for lenders and servicers at this point to keep in mind that, as you're doing your best to stay on top of requests for forbearances and categorize loans as either federally backed and therefore covered by the CARES Act or non-federally backed and therefore not covered by the CARES Act, but, still subject to this suggested guidance by the interagency statements, it's just imperative to make sure that you're keeping really good records, you're documenting requests, any accommodations that are made are being documented. And on a very practical level, what that means is I think a lot of lenders and servicers have to have a protocol in place, and they also need to have some training, perhaps, or adjunct training, if you will, to what their staff is already accustomed to when dealing with these types of requests to ensure that you're cataloging all of this information. Because, as David mentioned several times, we just don't know where this is going to end up ultimately, and it could go one of a couple of ways. And if it does end up in sort of the loan modification space, great. There's a lot more information to be collected and other steps that need to be taken. And I'm sure, most of us on the call are familiar with that process. But if it's not that, and if there's a potential for litigation, lenders and servicers want to be, again, in the very best position to have documented all of the communications, all of the steps that have been taken, and all of the outreaches with the particular borrower. So, again, this slide is just sort of our collective thoughts about compliance and litigation exposure that, we've identified to date. So making sure you're keeping those accurate records and maintaining your account management as well as you can and keeping in mind all of the accommodations and requirements under the CARES Act that we mentioned throughout this presentation. Here, there's no request under the CARES Act, no formal request for documentation or substantiation. It's literally just, a borrower calling in and saying, I've been affected by COVID-19 and I would like to take advantage of the forbearance that, I'm entitled to under this legislation. And I think there's an attestation, but there's really no documents that are going to be required on behalf of the borrower at this point. And so, again, that just leads to my earlier point, which is I think it's imperative to make sure that who's ever handling these phone calls, whoever's taking these requests and documenting them on behalf of the lender and or the servicer, just need to be impeccable in the way that's handled and make sure, again, that there's a protocol in place and that it's consistently applied. Again, I mentioned this earlier, the CFPB has announced that they're going to take this flexible approach to enforcement when it comes to credit reporting and that, the 30-day window is not going to be strictly applied for responding. But that being said, I think it's pretty common sense to appreciate that there is going to be an uptick in claims that are filed by consumers in the wake of all this. And the FCRA does, again, have that private right of action. So I don't mean to sound like a broken record, but that goes, again, to the point that I was just making of keeping accurate records, being consistent, having a protocol, making sure staff is trained, making sure everyone's on the same page. And this final point, I'll share with you, and then I may turn it over to David because I know he's particularly familiar with what's going on in Massachusetts, but the CARES Act doesn't contain any restrictions on debt collection. Even though prior versions did contain some language, it's not in the version that was actually enacted and passed into law. That said, there are some state laws that are out there that either restrict or, in the case of Massachusetts, plain out forbid any kind of collection on debt. So we're keeping our eye on that, and we're also, monitoring those state laws as we see them pop up and how it's all playing out. And David, I didn't know if you wanted to jump in and say anything about what's happening in Massachusetts.
Yes, thank you, Tanya. Thankfully for this constituency, the Massachusetts law exempts two categories of creditors, which one of them is mortgagees. So the Massachusetts law, which is a regulation promulgated by the Attorney General as an emergency regulation, announced on the same day it became effective, is inapplicable. But nonetheless, there are lots of these laws or regulations and the like that are being considered across the country. We have been looking very carefully at these laws for their vulnerabilities to being challenged through litigation, primarily on constitutional grounds. Some of these laws actually ban petitioning activity. The ability to go to court and to request relief in court and speak in court is something that is protected by the federal Noor-Pennington doctrine under the First Amendment. And the ability to engage in lawful, truthful commercial speech has also been a significant issue with some of these regulations that forbid substantively certain types of communications or contain what appear to be time, place, and manner restrictions, but really are more substantive restrictions on speech related to debt collection and the like. We do anticipate and frankly are being consulted by clients now about potentially bringing litigation to try to stop the enforcement and obtain declaratory judgments and restraining orders and eventually injunctions against these laws, which are making it impossible for our clients to continue to operate and do what they need to do to run their businesses in this time period. So there's just a lot of that out there. If there's any need that anyone may have on the call, we are truly at the forefront of all of this and are already over eyeball deep in it. So feel free, please, to reach out to anyone who is listed on this program. Tanya, I'll turn it back over to you. Okay, well, I'm not sure if we may have lost Tanya. Oh, there we go.
Hi, it's Annie.
Sorry, I apologize. I was on mute. Go ahead, Annie. I'm sorry.
No problem. We've been getting some questions about whether lines of credit are eligible for forbearance under the CARES Act. And so the answer to that is kind of a typical lawyer question. It depends. With respect to a home equity conversion mortgage line of credit, generally known as a reverse mortgage equity line of credit, the answer is likely yes, because those are generally insured by the FHA. With respect to a traditional home equity line of credit, those are generally not a federally backed mortgage, and therefore those, if they're not federally backed, would not qualify for any kind of assistance under the CARES Act. Across the nation, states such as California, New York, Rhode Island, and New Jersey, the state governments have been working with lenders and banks and servicers, asking that any kind of assistance that can be provided to consumer bankers, consumer banking clients be provided. But in terms of a non-federally backed loan, if it doesn't meet the very specific criteria of the CARES Act, then it does not qualify.
And I'm just going to jump in real quick just because I need to make sure our participants know how to ask questions before we move on to the next question. Ladies and gentlemen, at this time, we are in the question and answer session. To ask a question via the web presentation, just type your question into the text box at the bottom of your screen to be included. So please feel free to go ahead with the rest of your questions. And do you want me to go ahead and read the next question, or?
Oh, sure. Sorry, I can go ahead and read the next one.
Okay, great.
We're also getting, the questions are coming in fast and furious right now, so apologies for that. We are getting a lot of questions about what is going to happen at the end of these forbearance periods, and will a consumer owe $12,000 immediately if, for example, their mortgage payment is $1,000 a month and they take advantage of the full 360 days of forbearance? Or will they need to just begin paying $1,000 per month and their mortgage will be extended by another 12 months or a year? Right now, the end of the CARES Act and what happens, we're facing a lot of uncertainty. David or Tanya, I don't know if you want to weigh in on this point, but it seems like we haven't received any kind of specific and clear guidance to date.
So, the answer is today, what we know is that we know what a forbearance is, and when the forbearance is over, all the money comes due at once. So that's what we know today. What the uncertainty is that going to change? So between now and then. So right now, the way that the law currently stands, that $12,000, the entire $12,000 for the missed 1,000 month payments for 12 months, would become due and payable in full in lump sum upon the conclusion of the forbearance period, at which time you would expect the consumer to say, I can't pay it, and then if nothing changes between now and then, you would end up in a scenario where we would go back to the traditional toolkit of, well, okay, hardship request for relief, they can't pay it. Can we modify it? How could we modify it? Is it going to be put on the back of the loan? Is it going to be paid over a term? What's this person's financial hardship? We collect documents now because the law wouldn't forbid us from collecting hardship documents anymore. That's the way it stands today. The uncertainty is that really, if you have 15 million consumers who said, hi, COVID-19 ruined my life, not my fault, no moral hazard this time around, like we had in the last financial crisis. These are all folks who are swearing under oath that it was COVID-19 that did in their finances. Is this country really going to let all those folks have their homes foreclosed out from under them with no form of financial relief? We'll see. Nobody knows.
And that's definitely not the most satisfying answer for everyone, I'm sure. But as I mentioned earlier, we at Seyfarth Shaw are at the forefront of all these issues. We're staying on top of them, and as insight becomes available to us, we will synthesize it and, either do a follow-up webinar or be posting updates that hopefully everyone who's participating today will find useful. So again, we encourage you to sign up for those updates, as I mentioned earlier. And I see a couple of questions about whether we can make the materials from today's presentation available after the webinar, and the answer to that is sure, happy to make those available. I think we're at the end. That's all we have, unless David or Annie, you have anything else.
Just want to thank everybody for listening.
Yeah.
Well, thank you very much. This concludes today's webinar, and we thank you all for attending. Have a great day.
Thank you. Bye-bye.